Well, good afternoon, everybody, and welcome to this week's session of the Bonavero Discussion Group. My name is Téa Braun, and I'm the director of the Bonavero Institute, and we're particularly delighted to welcome today our two speakers. First, Téa Braun, who's the executive director of the Human Dignity Trust, based in London, which has done extraordinary work over the last decade in relation to issues relating to sexual equality. She's going to be talking today on the topic of challenging laws, progress and prospects in overturning 150 years of discriminatory sexual offence legislation in the Commonwealth. And her talk is going to be responded to by my friend and colleague, Justice Edwin Cameron, formerly of the Constitutional Court, a long-time human rights activist and campaigner, also in the field of LGBTI rights. So I think we're going to look forward to a really interesting exchange between the two of them. And just to remind you, this is in a webinar format so that you have a Q&A at the bottom of your screen on the right-hand side where you're able to put questions, which I will moderate to the speakers once they're finished. So please feel free to put questions in the Q&A and we'll attempt to put them to Téa and Edwin before this session ends. I'm going to turn over to you, Téa. Thanks very much for being here.
Thank you, Kate, and thanks to everyone at the Bonavero Institute for organizing this event and inviting me to speak. And thanks to everybody who's joining us today. I chose the title for my talk today, the first part, Challenging Laws, with a double entendre in mind. Firstly, as I speak about the history and evolution of discriminatory sexual offence legislation in the Commonwealth, a central part of this will be looking at challenging some of these laws in the courts, and specifically the global process that began in the 1970s and 80s of bringing court challenges to the laws criminalizing consensual same-sex sexual conduct. And secondly, the title alludes to a recognition that those laws and a much wider gamut of discriminatory sexual offence laws are challenging. They're challenging laws. They're difficult to dismantle. And that's because they are imbued with centuries-old social and religious norms, and they're deeply embedded in a huge global historical spider's web that remains wrapped around much of the world still today. So what do I mean by sexual offence legislation? I'm talking about laws that make it a crime to engage in certain conduct of a sexual nature and that legislate for the prosecution and sentencing of such crimes. The key provision I'll be focusing on is the law or set of laws that make it an offence for people of the same sex to engage in consensual sexual conduct. That's the focus of my organization, the Human Dignity Trust. But those laws targeting LGBT people are situated within and are part of a wider set of interconnected sexual offence laws that discriminate against and fail to protect several other groups, including women, children, persons with disabilities, notably rape and sexual assault laws, which I'll also touch on. So let's look briefly at all of these, or at some of the main ones at least. Firstly, the criminalization of consensual same-sex sexual conduct. There are today 72 jurisdictions globally that criminalize male same-sex conduct. And 44 of those also criminalize female same-sex conduct, about 60%. 35 of those 72 jurisdictions are Commonwealth jurisdictions. So just to put that in context, the Commonwealth currently has 54 member states, so a little over a quarter of countries globally, but they represent 50% of the criminalizing jurisdictions. So I'll be focusing on the history, development, and dismantling of these laws across the Commonwealth. The legal formulations of those laws vary. A few of the most common are, firstly, a buggery law. Buggery had been an offence in the written law of England since 1533, and indeed it was an offence even before that in canon law, having its roots in Christianity. But it was the version that existed in the British Offences Against the Person Act of 1861 that was spread to certain other parts of the world during colonial times. And that formulation was exported primarily to various parts of the Caribbean region and the Pacific Islands. And it's still found in 12 Commonwealth jurisdictions today. The second main formulation is carnal knowledge or carnal intercourse against the order of nature. And that spread around the world in a couple of different ways. The first step was that around the same time as the Offences Against the Person Act was being exported, the Indian Penal Code of 1860 was enacted by the British Legislative Council in India. And it was a consolidation of all existing British criminal laws into a single criminal code for application in British India. So a huge undertaking that began in the 1830s and became law in India in the 1860s. So not just offences against the person, but all criminal offences in one single penal code. And section 377 of that Indian Penal Code read, whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment, and it was up to life in prison. So no reference to age, no reference to consent. It was the act itself with anyone, anywhere that was criminalized. And the Indian Penal Code was then inherited after partition by Pakistan in 1947, later in Bangladesh. And it was also adopted by the British colonial administrators in other countries in the region. So Burma, Sri Lanka, Malaysia, Singapore, and Brunei. So it sprouted out from India to those other countries in the region, and it's still in force in all of them, with the exception of Singapore, which repealed section 377, but still has another criminalizing provision that captures male same-sex intimacy. So, you know, a bit like an airline route map, I think of this as. You remember those route maps in in-flight magazines, if any of us can remember what those look like, where it first went to India, and then from there it sort of spoked out to other countries in the region. About 40 years later, the Queensland Criminal Code of 1899 was enacted in Australia. And this was again an attempt to consolidate into one document all of the criminal laws applicable to the colony of Queensland, which had been scattered through hundreds of statutes and books on the criminal law of England. And it modified the formulation from India slightly, but importantly, it had the same provision: any person who has carnal knowledge against the order of nature, or permits a male person to have carnal knowledge of him or her against the order of nature, is guilty of a crime, reducing the maximum sentence to 14 years. But again, no reference to age, no reference to consent. So this provision doubled down, and it ensured that both the active and passive consenting partners were criminalized. And it also added attempted acts as a crime. That Queensland Code, again, if we think of a sort of airline route map, it first was then shared with Nigeria between about 1904 and 1916, at which point it was adopted by the Colonial Office as the model penal code. And then from there, it branched out to most of the African colonies and beyond, places like Papua New Guinea as well. The third main formulation is gross indecency, and that was a provision that was added in Britain by the Criminal Law Amendment Act of 1885, which read, any male person who in public or private commits any act of gross indecency with another male person shall be guilty of a misdemeanor. That was intended to make it easier to capture any form of male intimacy, not limited to penetrative sex, as the buggery law would have required. And that again was replicated around the empire at the time. And over time, it was also framed to be gender neutral, so to capture female same-sex activity. There are other formulations in the Commonwealth, such as common law offense of sodomy, which is still in force in Namibia and Eswatini, sexual relations with a person of the same sex in countries such as Cameroon, which criminalized much later. And in some Commonwealth countries, such as Nigeria, Brunei, Malaysia, various others that have an Islamic law tradition that sits alongside the British colonial penal codes, there are various Sharia law formulations that criminalize both men and women. So although many of the former British colonies have since done away with these laws, which we'll come to in a minute, the picture today is that 35 Commonwealth countries, or over 65% of the Commonwealth, still criminalize consensual same-sex intimacy over 150 years after those laws were first imposed. Sitting alongside those laws and passed around the empire via the same colonial route map are rape and sexual assault laws. And these, of course, are central to any effective criminal law regime. but their Victorian era formulations are deeply problematic, and they still exist in those forms around much of the Commonwealth today. I'll give just a few examples. Rape and sexual assault laws only protect female rape victims in about half of the Commonwealth today. So they were written as crimes committed by males against females. And while women and girls are overwhelmingly the victims and survivors of sexual violence, there must in law be equal protection for any survivor of such violence, including men and boys, but there isn't in many countries still today. And so long as rape laws are not gender neutral, the unnatural offenses provisions, the buggery, carnal knowledge type offenses we've just looked at, must remain on the statute books to protect male victims of rape. And those provisions have different evidentiary rules and they have different maximum sentences. So the result is that we have both unequal protection for different survivors of rape and a complete conflation of anal rape with consensual male same-sex sexual conduct. Similarly, rape within marriage is perfectly lawful in well over half of the Commonwealth today, with express exemptions for husbands to rape their wives with impunity. And that emanates from the 17th century British jurist, Sir Matthew Hale, a widely celebrated judge. Hale wrote, and I quote, "The husband cannot be guilty of a rape committed by himself upon his lawful wife, for by their mutual consent and contract the wife hath given up herself in this kind unto her husband, which she cannot retract." So that rather disgraceful belief was then wrapped up into the consolidated British laws that were spread around the empire, treating women as sexual chattel. And this is still the case in law in many Commonwealth countries today. Similarly, provisions that set the minimum age of consent to sexual conduct were systematically discriminatory of girls with younger ages of consent, which has fostered and enabled childhood pregnancies, child marriage, unequal access to education, among many others, for hundreds of millions of girls around the world. And these unequal and sometimes very low ages of consent still exist in about 60% of the Commonwealth today. Likewise, as with the general rape and sexual assault laws we looked at, sexual offenses involving children were written to only protect girls, leaving boys with no or with unequal protection. And that's still the case in over 60% of the Commonwealth. And indeed, that again means that rape or sexual assault of boys must be prosecuted under buggery, carnal knowledge, or gross indecency laws rather than rape and sexual assault laws, again, with different evidentiary rules and different maximum sentences. And one final example I'll give is the treatment of persons with disabilities in colonial era sexual offense laws, which have two main human rights problems. Firstly, based on a contemporary reading of them, there is a blanket ban on sexual conduct with a person with disabilities, leaving no room for autonomy and personal choice for those who have the capacity to consent. And secondly, they use language that today would certainly be considered deeply derogatory to describe persons with disabilities, such as idiot, imbecile, defective, and subnormal. At the time, those were medical terms describing nothing more than mental age, but clearly today they're offensive and need to be replaced. And both the blanket ban provisions and the derogatory language still exist in about half of Commonwealth countries. So coming back to my airline route map analogy, we can see that the British criminal law was a bit of a hub and spoke exercise, with the IPC first being the first export, and it then branching out a bit like spider's legs across the Asian colonies, and the Queensland criminal code being exported to Nigeria and then spider legging out across the African continent and so on. So the R rate, if you will, to use a term we've become all too familiar with this past year, of all of these discriminatory provisions was very high in the latter half of the 19th century and the early part of the 20th century. And sadly, the rampant viral hostility towards or marginalization of LGBT people, women, children, people with disabilities that we continue to see today is the legacy. And these laws, all of them, have brought death and destruction beyond comprehension. LGBT people have been murdered by their governments, by their communities, by their own families. Countless have committed suicide. Countless others have been raped, beaten, subjected to forced or pressured heterosexual marriages. Many have languished in prisons, all simply for expressing their sexual identity with a consenting partner. Married women around the Commonwealth have been treated like property and in many cases raped forcibly by their husbands with the state's blessing for centuries. And we could go on and on about the impacts of these laws. But for now, that's a very quick tour of some of the historical and still very prevalent problems of discriminatory sexual offense legislation around the Commonwealth. It's noteworthy to add that over 150 years after these laws began their journey around the empire, the former UK Prime Minister Theresa May rightly acknowledged in 2018 in what was a very impassioned speech during the Commonwealth Heads of Government meeting in London, that all of these laws were wrong then and they're wrong now. And the UK, to its credit, has since been investing in supporting efforts to dismantle all of these laws. So let's now turn to how change is happening, including the vital role of human rights law. Again, I'll focus primarily on the laws criminalizing LGBT people, but I'll also touch on the other discriminatory sexual offense laws. So England and Wales, the motherland of LGBT criminalization, repealed in large part, though not in full, its criminalizing provision in 1967. So about a century after the 1860 Indian Penal Code first came into force. Some Commonwealth countries like Canada in 1969 repealed shortly thereafter, and others would follow suit in the decades that followed. But this was also the era of decolonization and independence, and the process of decriminalization here in Britain left untouched the spider legs that were now firmly wrapped around the former colonies, and their laws were now their own to do with as they saw fit. It was also, fortunately, the era of the birth of contemporary human rights law and of independent constitutions and bills of rights, which have been instrumental in the process of change. There are, of course, two ways to get rid of discriminatory laws, through the legislature and through the courts. So if we look back over just the past 35 years or so, going back to the mid-1980s, 52 countries in total have decriminalized LGBT people in this period. So combined, that adds up to hundreds of millions of LGBT people who are no longer committing a criminal offense by engaging in consenting sexual activity consistent with their real self. So that's a major and powerful shift. Only 16 of these are Commonwealth countries, however, so not in proportion to their presence in the criminalizing picture. In terms of the method of decriminalization, 40 of the 52 have decriminalized through legislative repeal. That number, however, is skewed upwards by a large number of countries that had to decriminalize as a condition of entry to the Council of Europe. So an influence of human rights law in Europe. And it must be noted that some of those countries still treat LGBT people pretty poorly, however. Since the 1980s, there's also been a growing body of domestic, regional, and international case law on decriminalization, covering an increasingly expansive analysis of fundamental human rights. So I'll mention just a few of these, mainly to highlight this expansion in the law over time. So the first case of its kind was Dudgeon in the UK, which challenged the criminal provision that, despite the 1967 decriminalization in England and Wales, remained in place in Northern Ireland. In that case, it was argued and decided purely on the right to respect for private life. So the legal understanding of LGBT human rights was limited to what you do in your own bedroom is up to you. And indeed, the decision makes clear that same-sex intimacy was to be tolerated in law, but was still seen as capable of corrupting young people such that a higher age of consent was still valid in law. And Dudgeon was then followed in two other European cases, forming a trilogy, and they're all based on the right to privacy. Then in the 1990s came the first and still only case at the United Nations, the case of Toonen and Australia under the ICCPR, challenging the remaining vestige of criminalization in Australia. So it was similarly centered on the right to privacy, but it also, and without any analysis, finds a violation of the right to non-discrimination on grounds of sex. The arguments, though, that were put before the committee were on the narrow basis that the law only criminalized male same-sex conduct and not female same-sex activity. But nonetheless, there's a slight wedging open of the issue of non-discrimination as a relevant right here. In the first successful domestic constitutional case on the topic, the 1998 National Coalition case from South Africa, that case went further and took a much more expansive and holistic approach to human rights, thanks in large part to a generous set of human rights contained in the post-apartheid constitution and a very elegant judicial analysis in which our host, Kate O'Regan, was one of the concurring judges. The judgment finds that the sodomy law violated multiple rights, including, but not limited to, privacy. And particularly in the concurring judgment of Justice Sachs, it took a very holistic and integrated approach to fundamental rights. The judgment firstly afforded a wider understanding of privacy as a right to a sphere of private intimacy and autonomy, which allows us to establish and nurture human relationships without interference. And which also imposes some responsibility on the state to promote conditions in which personal self-realization can take place. So very much not limited to a notion of privacy of what you do in your bedroom is up to you. It also recognizes that the right to dignity, which is contained in the South African Constitution, requires us to acknowledge the value and worth of all individuals as members of our society. And it drew analogies to the discriminatory apartheid era bans on interracial relationships. And it finds that the breach of the right to equality before the law and non-discrimination, South Africa being still today, one of the rare exceptions that has an express inclusion of sexual orientation in its non-discrimination provision. There's a progressive expose in the judgment on the purpose and importance of the right to equality and recognizing and celebrating difference. The judgment analyzes all of these rights, both individually and taken together, and how the sodomy law violated the basic integrity of gay men across all aspects of life and in the eyes of the community at large. So by the end of the 20th century, we had a small but growing bundle of case law recognizing that maintaining consensual same-sex conduct as a sexual offense violates the rights to privacy, dignity, and equality before the law, with a trickle of case law on non-discrimination. And although there are several other cases on this issue, I'm going to jump ahead to the two most recent final decisions, the Orozco case in Belize, which was decided in 2016 and upheld in the Court of Appeal in 2019, and the Indian Supreme Court case of Johar, which was handed down in 2018. Mainly to note that these are the first domestic cases to take human rights another 2 or 3 steps further in recognizing all of the rights I've just mentioned, plus the rights to non-discrimination on grounds of sex and freedom of expression, as well as, in the case of Johar, the right to health. Although Tunin had laid the groundwork for the sex discrimination argument raised in Orozco, a much broader conceptual understanding of sex was put before the court, that it's not merely engaged when the state criminalizes only male same-sex conduct and not female same-sex conduct, but where the state applies gender stereotypes to matters of sexual intimacy. So that is, one cannot discriminate on the basis of sexual orientation without, by definition, discriminating on grounds of sex. It's imbued with gender stereotypes. And this is an important new and developing area of jurisprudence still today. It's further aided by an important line of cases that's developing in the US in the context of equal opportunities legislation, both because it expands our understanding of discrimination and the stereotypes that underlie it, and also because on a practical level, virtually all countries have an express prohibition on sex discrimination, whereas most do not have an express inclusion of sexual orientation. And properly understood, therefore, there needn't be an additional express protection against sexual orientation discrimination. Secondly, both of these cases, for the first time ever, recognize that anti-LGBT criminal laws violate the right to freedom of expression. That's a novel and expansive understanding of expression, as including sexual expression and expression in choice of a sexual partner. So that's really revolutionary in this field. And finally, the Johar decision also includes a first of its kind judicial affirmation that the constitutional right to health, as in India read into the right to life, is violated by laws criminalizing consenting same-sex intimacy. So the court recognizes that these laws serve to push people underground, LGBT people underground, and fundamentally out of reach of vital sexual health information, including HIV prevention and treatment, as people who engage in same-sex intimacy would risk criminal sanction if they sought sexual health advice. So why would they Why would they do that and put themselves at risk? So that's a major legal advancement, although it's still relatively rare in criminalizing jurisdictions for there to be an express constitutional right to health, unless courts read it into the right to life, as it has been in India. There's ongoing strategic litigation along the same lines in many other countries today, with domestic cases in Mauritius, Malawi, Kenya, Singapore, and several Caribbean countries, as well as a regional case at the Inter-American Commission on Human Rights against Jamaica, on which we hope to be able to announce a decision early this year, and a first of its kind case filed in 2018 against Sri Lanka at the UN CEDAW committee. Again, a very novel case challenging and bringing attention to the criminalization of lesbians, which could be decided in the next year or so. So the global progress in overturning this particular category of sexual offense is clear and consistent. And despite how challenging these laws are, these maps you're seeing now remind us that history is very much moving in the right direction. The first three maps are not specific to the Commonwealth. They show in black the global prevalence of criminalizing laws at the height of the colonial period of 1920, which was pretty bleak indeed, to the early stages of dismantling of these laws as of 1981, and to today, which, while there's still a long way to go, is a much different picture. The Commonwealth countries that still criminalize LGBT people today are represented in this next map. The smaller countries are harder to see, but there are still 9 Caribbean countries and 7 Pacific Island jurisdictions that criminalize. And indeed, all of the criminalizing jurisdictions in those 2 regions are Commonwealth jurisdictions. Again, spotlighting the disproportionate role of former British colonies in the overall picture. I said I would also touch on progress on the other discriminatory sexual offenses to which I made reference earlier, which I'll do just very briefly in the couple of minutes that remain, and by reference to the alternative process of change of legislative reform. So while there have been relevant court challenges to some of those discriminatory laws, including the landmark UK House of Lords decision of R&R of 1991, which finally struck down the marital rape exemption in the UK, much more reform has taken place through legislative updating. And that process, where it's feasible, has the benefit of being holistic. It presents an opportunity for tackling all of these discriminatory and outdated provisions together, rather than on a piecemeal basis. Certainly there has been piecemeal updating of rape and sexual assault laws, and there's been standalone repeal of the laws criminalizing LGBT people. But the wholesale approach has had some real traction in recent years, and it's a model with great scope for emulation. For example, there's been a complete overhauling in recent years of either the entire colonial era penal code or of the sexual offenses chapter within it in countries like Palau, Nauru, Mozambique, Belize, and Northern Cyprus. And those resulted in the removal of numerous discriminatory provisions, more or less in one go. So making rape laws gender neutral, expressly criminalizing marital rape, removing buggery or carnal knowledge type provisions in their entirety, equalizing ages of consent, removing derogatory language in reference to persons with disabilities, and so on. And that process of cutting the legs of the spider and starting over with reference to human rights norms is ongoing elsewhere. So our relatively new work at the Human Dignity Trust since 2018 in providing technical legal assistance to governments for legislative reform, where they want to embark on legislative reform, has already resulted in drafting fully revised sexual offenses bills in 2 Commonwealth countries. So in summary, there's both a lot of progress and a lot of work still to do in the Commonwealth around the whole gamut of sexual offense legislation. And I think it's imperative that these issues become more front and center in Commonwealth debates and agendas, given the disproportionate representation of the Commonwealth in maintaining these discriminatory laws, but also given their shared legal frameworks and the shared legal history that I gave a quick summary of. Kate, there's a lot more I could say, but I'll leave it there with many thanks again to you and everyone for taking an interest in this topic. Thank you.
Thanks, Téa, for that really comprehensive account. And I must say, I found some of those maps really very interesting indeed. Turning then to you, Edwin, for your comments.
First of all, I'm really very pleased to be here. And second, thank you to you, Kate, and to your colleagues at Bonavero for organizing this. And third, Téa, thank you very much indeed for an extremely concise and lucid and penetrating exposition. I really appreciated that, and I hope that I myself and the other participants will be able to get your paper, because it's an up-to-date overview of a high quality, which will be very helpful as both an analytical but also as an activist tool. So thank you very much indeed, Téa. Before responding to your presentation, Téa, and I have 3 comments, general comments. I want to ask that we shouldn't go back a few steps. And the reason is that you rightly point out that the anti-LGBTIQ provisions, which still deface the legal systems of so much of the world, were partnered by very, very sexist and very, very demeaning anti-disability provisions as well. But I think that there are special factors which explain the persistence and stigma relating to LGBTIQ people. And I want to pause with them first. And I think the first of these 3 factors is that we are mostly invisible. Most gay men, lesbians, and transgender people are not readily identifiable. This means that identifiability, therefore, is, although not always, often a political choice, an express political choice to come out, whether to one person or your family or to many more people. And this invisibility has a severe social and political consequence. It enables leaders in deeply repressive anti-queer societies in Africa, the Caribbean, the Middle East, and elsewhere to lie about us, to lie about our existence. In fact, we know that we form and have always formed a small minority of humanity, an enriching variant, perhaps 7%. Some people want to say 10%. I'm not so greedy. I think 5 to 7, maybe 10%, in all cultures, in all religions, all regions, and at all times in human history. It is only the social recognition, politicization, and criminalization of LGBTIQ identity that has differed and that is now evolving, which is what we have been discussing. We have always been here. The second feature that explains the enduring stigma and the difficulty of dealing with this in Africa and the Caribbean and elsewhere is that this is about sex. When I identified myself as I am, as a proudly gay man, I'm telling you something enormously intimate about myself. I'm telling you about my sexual functioning, my sexual preferences, if one can talk about preference there, about my deep erotic being. Lesbian, gay, and transgender identity relates intimately to sexual functioning. And this is still something of a taboo in many parts of the world. It complicates our fight for dignity and equality. And the third factor bearing upon our continued stigmatization is monotheism. I often like, when audiences are live, to single out the Catholics at this point. Kate, at one point you were a self-identifying Catholic, am I right? But I'm very happy also to tease the Jewish and Muslim members of the audience. Monotheism, the Judeo-Christian and Muslim religions, including vicious misinterpretations of the Mosaic and New Testament texts, have been used to persecute and terrorize us as immoral, ungodly, unbiblical, alien, and abnormal. And that is happening right now today in too many parts of the world. In South Africa, we as a British colony from 1806 were subjected to these repressive and stigmatizing laws that Téa has so lucidly exposed. We had our own long struggle against the shame, repression, and injury that they inflicted. By very great good fortune, and this leads me to my first comment about Téa and the organization she works for, the gigantic struggle against apartheid that saw a mass popular uprising take place during the 1980s brought to the fore a young man from Sebokeng, about 60 kilometers from Johannesburg, south of where I'm sitting now, called Simon Tseko Nkodi, with almost unimaginable courage, Simon proclaimed, "I'm proudly black, I'm proudly gay, and in opposing apartheid, I also oppose my own oppression as a homosexual man, and I refuse to splinter off these different aspects of my humanity." Simon's courage as an anti-apartheid activist, he was tried for treason and murder and eventually acquitted, boosted arguments for LGBTIQ equality. 31 years ago today, on the 2nd of February 1990, the apartheid government in effect started to throw in the towel. It didn't do so comprehensively, but negotiations to end apartheid began. We were able to argue during those negotiations that the new democratic constitution should include recognition for sexual orientation. As a result, our final constitution became the first in the world to prohibit unfair discrimination on the grounds of sexual orientation. And here's my point. Simon's visibility as a proudly and assertively black queer man opposing apartheid, opposing these laws as a colonial import, helped us inordinately and probably pivotally. So Téa, the first thing I want to say is that the Human Dignity Trust, to my knowledge, has been exceptionally attentive to the question of identity, to the question of replicating colonial patterns and stereotypes, colonial hierarchies. You have, I understand, I thought that your presentation might have spoken a bit about this, so I'll compress what I have to say here. My understanding from you and from other members of the Human Dignity Trust is that you are profoundly aware that you are a mostly, though not exclusively, white-led organization in a still largely white country, in a very largely white city of London, and that in offering assistance, offering subvention, offering advice to the people who wish to challenge these laws in the Caribbean and Africa and elsewhere, you give priority to visible local actors and visible local agents. And I commend that. My second observation is about law and the rule of law. And I make it as a South African in a country that has been, I think, rightly buffeted in the last few years, more or less since the death of Mandela in December 2013, about 7 years ago, has been buffeted by a spirit of anti-law skepticism, anti-constitutional skepticism, anti-rule of law skepticism. What has the Constitution brought us? A lot of angry young black people, I think, rightly say. And of course, here we are talking about colonial era legislation, laws which were brought into our country, which are part of this apparatus that they are querying. More specifically, they were imposed by male-only governments in a male-only elite in a deeply repressive society, Victorian Britain, which was only very partially democratic. In the last 4 decades, there has been considerable movement towards recognizing the narrowness and inappropriateness of these strictures and their provenance in the Commonwealth. And the HDT, Téa, and you and your colleagues have been helping that. But there have also been feelingful setbacks, anti-democratic, anti-constitutional setbacks. Let me mention President Magufuli of Tanzania, and the President of Zambia, and President Museveni in Uganda. There have been shameful attacks on democracy, upon the rule of law, upon the elements of fairness and freedom and autonomy that should go with the rule of law. Commitment to the rule of law entails that there must be some, even rudimentary or even incipient, commitment to equality and dignity, and also to scrutiny of official conduct. The corollary or converse also applies. Without a profound commitment to equality and dignity, you can have only the most tattered and superficial form of the rule of law. I'll circle back now to where I started with this, my second point, which is that whatever skepticism we have about the law, whatever skepticism we have about rights and about constitutionalism and about what they can deliver, they're the best we have. And I think that the legal process is the best way, combined with my first point, which is local activism, local agency, local visibility, visibility like Simon. And we have brave, incredibly brave men and women, transgender persons across the Commonwealth, across the world, who are doing exactly what Simon did nearly 40 years ago in South Africa. And now my final comment. It is that the homophobia we are dealing with is not limited to the overtly repressive societies that form the principal background to the principal battlegrounds about these laws. In societies where formal equality and even constitutionally protected equality and dignity have been enshrined, the battle against deeply persistent anti-queer attitudes continues. In my own country, public discourse, at least, is governed by an explicitly pro-LGBTI protocol. Any politician, singer, entertainer, or sports star who expresses homophobia is instantly rebuked and often badgered into apologizing, and rightly so. I won't pause to talk about some of the nonsensical arguments about cancel culture, rightly required to apologize for injuring other people's dignity and equality. Even Mr. Jacob Zuma, before he became president, was forced to apologize for a homophobic slur. At the same time, we have the continuing fear of repression in South Africa, despite our 26, nearly 27 years of sexual orientation enshrinement. And this is enacted largely along race and class lines. A Black lesbian living in a township or informal settlement is much more at risk for her personal safety, even for her life, than a white gay man like myself living in an affluent neighborhood as I do. The point about enduring deep homophobia holds true also in the United Kingdom. There's a deeply residual homophobia that persists even after the sodomy laws were repealed 11 years after the Wolfenden Report, even after Margaret Thatcher's malevolent Section 28 was repealed, even after the age of consent was equalized, and even after equal marriage rights were eventually afforded. The residual homophobia manifests itself, I think, in at least some of the reaction to the current debate in Oxford, where the Bonavera Institute is, about the struggle by two lesbian women in a Commonwealth country, the Caymans, who wish to marry. The form the debate has taken in Oxford is whether the head of a college, who is a senior legal practitioner, can comply with their duties of equality and respect to the college community at large, including its LGBTIQ members, while prosecuting a government brief that seeks to deny the two lesbian women an equal right to marry. That debate has been obfuscated, possibly, I think one can say with reasonable warrant, disingenuously, by recasting it as one about the bar's professional rules. In truth, it would appear that the rules relied upon are inapplicable. The Caymans are a foreign jurisdiction. All its courts, including the Privy Council, apply Cayman's law, not English or UK law. Hence, what is at issue is foreign law. And Rule 30 of the Bar Rules in London provides that the so-called cab rank rule that has been invoked does not apply to, quote, any foreign work. The point I make is not the diversionary point about the precise meaning of this exemption, which seems reasonably clear, but about the way it has been drawn in to obfuscate the debate and how permitting that to happen is itself a manifestation of a deeply latent and persisting homophobia. My close friend and colleague Gilbert Marcus has recently explained the issue has been framed as one of compliance with the cab rank rule and the duty of a barrister fearlessly to represent their client. It is nothing of the sort, Gilbert says. The issue is the compatibilities of the duties of a college head with their representation professionally of a homophobic cause. Once they accepted the headship, their duty was to the community of the college and to the LGBTQI people to ensure that they could enjoy a safe and supportive environment in which they could flourish. The anti-marriage brief is strikingly at odds with that duty, and the conflict is palpable. Ben Gilbert says it would be like the head of the anti-apartheid movement accepting a brief on behalf of the apartheid government to defend the prohibition on interracial marriage at a time when South Africa still enjoyed an appeal to the Privy Council. Gilbert concludes most people immediately grasp that example, but somehow, and this is my third point about Téa's presentation, but somehow a different standard applies when it comes to equality for LGBTIQ people. My point is the apparent ease with which this debate has been deflected from one of moral responsibility to uphold the dignity and equality of LGBTIQ people to the alleged professional duties of a legal practitioner. And this, like Gilbert, I ask, would the debate have taken the same form if the issue were a Muslim ban in a Commonwealth country, as President Trump tried to enforce? Or the prohibition was, as in apartheid South Africa, as Téa rightly reminded us, Justice Laurie Ackerman on the bench that Kate also sat in 2009, were a ban, like in apartheid South Africa, on a white person marrying a black person, or if, as in Nazi Germany, a ban on Jews or Roma people marrying non-Jews. Would we have afforded a college head who took a brief to defend laws of this kind the same pass? In my view, the levels of concerted outrage would have been almost unimaginably different. And why is this? Is it because LGBTIQ dignity and equality are of lesser value than religious respect and worth, or racial equality, or of any other form of human dignity and equality? Some commentary has almost made it seem as if LGBTIQ people should be grateful that the Caymans bestows at least some recognition on their partnerships, as if they should curb their impatience and be more congenial to those professionally arguing against their own equality and dignity, as if the fact that there might be an interesting, and I'm quoting, constitutional question about the meaning of the Constitution in the Caymans is enough to shut them up. Instead, I suggest that it is outrageous that in civilized circles in London, Oxford, or elsewhere, we should be acquiescing in or affording respectability to efforts to impede equality and dignity in any part of the Commonwealth and in any part of the world. Thank you.
Thanks, Edwin, for, as usual, arguing your case with great passion, and it'll be interesting to see whether there are questions that arise in relation to that. But I want to go back now to talking about particularly kind of Téa's presentation. And Téa, we have a range of interesting questions, and one of them is what the role is of litigation versus legislative reform in seeking decriminalisation. And I might add to that, what is the role of referenda? Because of course we're very familiar with the kind of recent move to referenda in this area, and it links a little bit to Edwin's point about the persistence of homophobia in circumstances even where kind of constitutional provision or a legislative provision is adopted that asserts, at least at the level of law, the equal rights of LGBTI people. And I just wondered whether you've got thoughts on thinking about this in relation to the form in which that assertion of equality is made as a result of either legislation or a referendum or litigation. You're on mute, Téa.
Apologies, thank you, Kate. Yeah, I think litigation and legislative reform will always have a role, and it's very much a question of context-specific possibilities. So there are, I think, three categories of country. There are those that are hostile to LGBT human rights, or indeed change in the other areas that I touched on. And in those cases, the possibility of legislative reform, certainly anytime in the near future, is virtually non-existent. where there are functioning independent courts, at least, litigation may well be the only approach. In some countries, there are neither. The courts themselves may not be effective, and there may not be either opportunity. But then there are the movable middle countries where there is some political recognition of the need to change. Often that political recognition it has difficulty surfacing because politicians are, they're looking at the next election, and the issue may not be socially acceptable. But where there is the movable middle, the countries that recognize that these laws need to change, then legislative reform may be the more effective option. So I think it really depends on the country, and both will always have a role. It will never be an either or. Referenda, I'm not a fan on people's rights being subject to a referendum. That by definition means that the majority can decide who gets their fundamental rights. I think fundamental rights belong to everybody and are more important for those that don't have a political voice. So I wouldn't see much of a role for that. But as between litigation and legislative reform, and sometimes it's both. It's not necessarily either or. There are cases where, contexts where there's a case being brought in court and a parallel legislative reform process happening, and they can play off of each other. I think the major point is we have to use all of the tools. In the context specifically of decriminalization of LGBT people, sometimes legislative reform can be more palatable if it is the wholesale reform that I was talking about, or it can have greater chance of success. So there are a number of countries recently that have decriminalized through legislative reform, but it's been a wholesale reform. So it's not spotlighting the issue of decriminalization. That's one of many outdated laws that's being changed. So it's very much, these are strategic questions, they're political questions, they're legal questions, and they're contextual questions, and they're all subject, not referendum, but litigation and legislative reform are all tools that we have to be using. You're now on mute, Kate.
Thank you. Before turning to Edwin, could I now just follow up on that slightly, which is there a difference between clearly removing a criminal prohibition is an enormous liberation for the people concerned, but I'm wondering about whether it's different in circumstances where that prohibition has not been used. I'm really trying to wonder, is there a difference between marital rape in this area and the situation in relation to same-sex consensual relationships in terms of how effective, we haven't seen that much litigation, I don't think, on marital rape, but I just wondered whether you think there's any difference depending on the kind of the character of the criminal offence concerned. And then Edwin, will come to you in a mo.
Sorry, that was to me or to Edwin?
To me, yeah.
Yes, no, you're right. I mean, it is more, that has been more changed through legislative reform. I think it attracts, surprisingly, to many of us, the same pushback. It seems obvious that exemption should be removed, but the pushback that you get from the same groups, it's the religious opposition, the religious leaders that have voice in the religious communities oppose that change. And so even legislative reform that might seem fairly straightforward on that topic is not necessarily easy. That again, it's not an issue that we are particularly working on in terms of litigation, so I can't comment on the prospects per se of using litigation specifically on that issue. But just to say that it comes up against the same opposition and the same challenges.
Thank you. Edwin.
Thank you, Kate. Just to join with what you and Téa have just been saying, I think that the notion that a woman is the object of her husband and is subordinate to her husband's sexual pleasure is part of the objectifying of women, but it springs from the male hierarchy, which we're still dealing with very much in our country, in Africa and elsewhere. And it's the same male heterosexual hierarchy that wants to prescribe to other males and especially to women. And there are slightly variant ways in which this is expressed, that males shouldn't be doing what they want to do together and a woman should be available to a man. So it springs very much from the same noxious and pernicious gender hierarchy in society. I want to speak very briefly about the question that Téa addressed, because I think it's a particularly important one, about legislation and judicial reform. And I think both of them have as anterior to them the need for, it's not always possible, the need for a visible local activist movement. That takes me to my first comment on Téa's paper. We had Maurice Tomlinson in Jamaica. He's had to have been based elsewhere later, but he started J-Flag with extraordinary courage. The big thing about the LGBTI community is that people don't think we exist. We know that women exist, and we've seen how difficult it has been for them to claim their equality. It's been an agonizing and long walk, and still is with sexual autonomy rights might perhaps being a judicial risk in the United States. But it's much more difficult when you don't know that there are people in your own society. So I think the activism of visible queer people in each society can often be decisive in showing people, often in the families of the Chief Justice or the cabinet ministers or the Prime Minister or the President themselves, that coming out and activism linked to coming out can often be pivotal, whether to legislative or judicial initiatives.
Thanks very much. And then the next question, I mean, Téa touched on it in her presentation, but is the risk of sort of backsliding, the risk of, once having achieved kind of a repeal of kind of unequal and repressive legislation, what the risk is of actually returning to it. We might not have asked this question 10 years ago, but seeing the kind of patterns of an emergence of a particular form of sort of nativist, conservative populism around the world, do you see this as a real risk?
Often this is a two steps forward, one step back picture, and as Edwin touched on, even decriminalization itself, if it's maintained, is not a panacea to everything else. So it is about incremental progress. It's about certainly setbacks along the way, even the setbacks in court, and we've seen many of those. Where in the U.S., for instance, in the 1980s, there was a Supreme Court decision upholding the criminal law, and it took until 2003 for that to be reversed. We saw the same thing in India. Delhi High Court, in a brilliant judgment in 2009, decriminalizing, only to be reversed in the Supreme Court, some years later, happily revisited again by the Supreme Court. So certainly there's, whether it's through governments or through courts, there are setbacks. But again, I stand back to the big picture that is shown in our maps, that despite the setbacks, despite regressive actions that are happening in a number of countries, some of which Edwin touched on, the overall picture is very much progress. It's very much, the arc of history is very much moving in the right direction, and we have to endure the setbacks as we go along. It's part of the reality of any kind of difficult social change.
Kate, I want to agree with Téa. I think that if one looks at California, for example, the 52-48 vote just 13 years ago to undo the California Supreme Court's decision to grant marriage equality, to assert that under the California, there was an alteration, and just 2 or 3 years later, the opposition had diminished, partly because of consistent activism. And of course, you bring about changes in public attitudes. I don't say that it's easy for people to do what Simon Cordy and Maurice Tomlinson did in Jamaica and South Africa, but I do. It's not a sunny thing that Téa and I are saying. We're not saying that it's easy to be queer in Indonesia or in Pakistan, but we are saying that the arc, and I like the weighted word you're using, Téa, that there is progress, and that the progress is there because queer people, visible queer people, outspoken, assertive, dignified queer people, and their allies are making that progress. progress.
Thank you. And then I'd like to turn to a question about the project of using litigation to address these issues, and particularly the risk of that being seen as some kind of neo-colonial project for an organisation like the Human Dignity Trust, based as it is in the UK, and this kind of idea of the kind of West visiting other parts of the world with its own kind of moral views. I mean, as I say, the question really is that this can also go hand in hand with criticisms of the overall international human rights project as a neo-colonial project. And what do you think? How do you think we should approach these kind of critiques and these kind of risks in relation to sort of supporting and bringing litigation of this sort?
Well, 2 points on that, Kate. Yes, it is sometimes a critique, although much less so than it was, say 10 years ago. Firstly, I rarely see any of these issues as North and South. I know some people choose to. I see these issues, all human rights issues, as pro-human rights and anti-human rights. And there are both factions in the North and there are both factions in the global South, so to speak. So I see it as an allied pro-human rights movement. But secondly, none of these cases that certainly that we're involved in are being driven by London. In every single case, we are assisting, often completely behind the scenes, at the request of local LGBT organizations, local activists, local lawyers who want to take on this issue, and they are driving everything to do with the case. If they did not want to bring a case, we would not do anything. When they want to bring a case is up to them. We are, and we specifically stay under the radar quite often in the best interests and at the request of our local partners. They must be in the driver's seat. They must be the ones deciding on the strategy, and they are the ones deciding that they want to choose a litigation approach. So this isn't a global North agenda at all. And I actually find that suggestion, which is often the suggestion of the opponents, that this is a global North agenda, that undermines the LGBT people locally that are the ones actually setting this agenda, which we are merely assisting with lawyers all around the world. And we have a Commonwealth group of experts that helps us, and they're from all parts of the world, all parts of the Commonwealth. So yeah, I think in a way it's a false critique. I can appreciate that there can be ways in which global North organizations can be working in that sort of way, but that's not how this type of litigation is happening.
Thank you. Edwin, any thoughts on that?
Please, Kate, thank you very much. Just 2 quick comments. The irony is, of course, that the recidivist attempts to sustain homophobia in Africa are often generated by far right-wing American white evangelicals, especially in Uganda. So there's that bitter irony. The second is that it's another, it leaves a sour taste, but I think there is agreement amongst activists in Africa that Prime Minister David Cameron's challenge to Malawi, it went a few years back, it was in the mid-2000s, I think, where he sought to make foreign continuing aid to Malawi dependent on non-homophobic progress in Malawian laws. That is generally acknowledged to have had a retrograde effect. So there's a need for deferring, as I indicated in my first comment to Téa's presentation, to the agency of local people, right through. There are many things that Prime Minister David Cameron could have done that wouldn't have boomeranged in that way. And it's a great pity that he didn't do them, but they would start with the agency, autonomy, and primacy of local people and organizations.
Yeah, thank you. And that brings me to another question that's been put, which is what the role is of parliamentarians, members of parliament, in achieving this kind of change, particularly in hostile environments where they may form quite a minority. Have you seen patterns in the way in which parliamentarians who would be sympathetic to these changes, but who can't necessarily bring them about in their own jurisdictions, have responded to this that you think are worth remarking upon?
Yeah, I mean, obviously, with legislative reform, parliamentarians will be key at the end of the day. And I think there are in many countries some subset, how large or small depends, but some set of parliamentarians who are already sympathetic to the issue. There are a whole lot more who need to be brought on board. And the process of bringing them on board is key and is important, and there are groups that work specifically on that. So ally building alliances within parliaments is key, and also informing them and equipping them really with the information that they need to be an ally and to understand both the social and contextual, but also the technical legal reasons and methods for this type of change. So yeah, certainly in terms of legislative reform, they're key. But even outside of litigation or legislative reform, the more that parliamentarians can understand and play a role in this, the better for everybody. Part of what we do as well at the Human Dignity Trust is in parallel with any legal work is public education campaigns where we can. That's very much subject to funding, but and that's really across the board. That's educating everybody in society about why these issues are important, and we have had the odd MP who has stood up and say, this is wrong, these laws need to change. So we need more of those champions out there in every country.
Thank you. Edwin, anything you'd like to say about that?
I don't think specifically, Kate, but I do think that public representatives, activists, and lawyers have an integrated and reinforcing role to play, and that parliamentarians also have an important role, even when they are an isolated minority.
Yeah. Thank you. So then one of the questioners asked how effective the reporting process of the UN treaty bodies are in this regard. States parties reports, concluding observations, the kind of particularly the UN Human Rights Committee regular reporting systems. Have these been effective at all as a tool for examining and putting pressure on states to address legislation in this field?
They have been, but it depends very much on people who make sure that it's in the list of issues and it's on the agendas. So the shadow reports from civil society are key. Often if those shadow reports aren't going in, the topic might just not come up at all. But where it does come up, the treaty bodies are providing really useful concluding observations and urging states, and we then use those in courts. Those are additional tools for whether it's litigation or legislative reform. So very much part of the ecosystem, but it does depend on civil society again, often making sure that issue is brought to them. Similarly, the charter mechanisms, the UN Universal Periodic Review process, where those reports are going in and the data is going in, the issues get raised, and the UPR reports end up commenting on it with all sorts of comments on all sides of it, of course, in that type of peer review mechanism. But and likewise, bringing cases before those treaty bodies. As I say, there's only one at the moment. There's only at the UN level. There's only the Tunin case. We have, as I mentioned, there's a case that's been filed at the CEDAW committee, and we want to see the expansion of UN law on this, that these laws also violate not just the ICCPR, but the CEDAW convention, various other conventions that need to be leveraged. So yes, very much a part of the ecosystem, and when it's engaged, it is definitely providing support and commentary.
Yeah, thank you. Edwin, any thoughts on that, or the intersection perhaps between domestic jurisprudence and the international human rights law?
Just a slightly tangential comment, Kate, that the most significant Africa-wide statement in favor of LGBTI equality was a momentous statement about 6 or 7 years ago from the African Commission on Human People's Rights, which decried violence against all people because of their identity or because of their perceived identity. It included transgender, intersex people. It was quite a remarkable statement. And Téa, I'm not sure to what extent that was informed by local activists in various countries, but it will be a very nice affirmation of your exposition just a minute or two ago, if that is the case. And I could try to find out from my activist friends in South Africa. But just the second point I want to make, apart from mentioning the 2014 resolution of the African Commission, is also that it indicates the significance of international bodies. The Human Rights Commission's appointment of a special rapporteur on violence against LGBTIQ people was of the greatest importance, carried by 22 votes to 20. First opposed by South Africa, the first country in the world that had a sexual orientation clause, and then South Africa flipped its vote and became supportive. So it's a slightly tangential answer to the question that our participant asked, Kate, but I think it's of enormous importance to invoke the international order. And as you said in putting the question, it's not an easy time for the international order, but maybe with new leadership on one side of the Atlantic, those organizations will receive some strengthening. And certainly for this topic of this afternoon, enormously important.
Thanks, Edwin. I think it would be very helpful, actually, if you can provide us with a link to that. We can share that with people who've participated. And that brings me, Téa, to another of the commenters who wanted the reference to the case that talked about sexual identity as a form of expression. So I think that's either the Belize case or the Indian case. But if you could let us have the reference to that, then we will just do a post discussion circulation amongst participants, so that people who wanted those references could do that. So the two of you just have those, that would be great. The last question that we've got, or maybe the second last question we've got, is whether you could highlight, Téa, some of the resources that are necessary to mobilize local organizations and advocacy groups. So it really comes back to Edwin's first point about the importance of the local kind of mobilization around these issues, and what resources are needed, in a sense, to set that going.
Is that referring to financial resources?
Well, I think it's referring to, it does talk about human resources. It's more than that. I think it's thinking about organizing and mobilizing around these issues, you know, what you would need to do that. And there's a similar question, in a sense, in relation to Cameroon, how organizations in a country like Cameroon could get involved in establishing local mobilization around LGBTI rights.
Yeah, I think it's there's a full range. I think you know, LGBT civil society is in many countries very well developed, and that's been a big shift over probably the last 10 years or so. So it's a sophisticated movement, and it's a globally interconnected movement. That said, I'm aware that there are other countries where it has been less resourced. It's much more difficult to even be LGBT civil society, certainly to be you know, in the public sphere at all. So I think it's a bit of a mix. You know, there is, for instance, if in the Commonwealth space, there is a network of global LGBT civil society called the Commonwealth Equality Network that some may know about. And I think joining those spaces, if people are not already in them, can both lead to greater information and greater information sharing and greater access to resources. You know, there are, in terms of funding, there are a number of funders funding LGBT movements globally. It can be difficult for smaller organizations in countries where it's difficult to even exist as an organization. You know, a funder is going to want an organization with a bank account and an address to send money to, and with financial systems and reporting capacity and everything else. So often it means starting, you know, small and building yourself up. But even that can be difficult, where it's illegal to even register as a civil society organization, which is the case in many criminalizing countries. So it's a complex problem. But I think, you know, to the extent possible, joining the networks that exist, building alliances with those, you know, more established groups, trying to, you know, have a presence at places like the African Commission, the civil society meetings at the African Commission, and Resolution 275, which you referred to, Edwin, was very much driven by civil society in Africa, mobilizing, meeting with the commissioners, building up the alliances, providing the materials and the reasoning and the justifications, and eventually that then being taken up by the commissioners. So yeah, it's a difficult question, and it depends, you know, on the country in particular. But there are networks out there that very much can help, you know, build up that capacity.
Well, that's very helpful, Téa. And presumably, if you know, if any of our participants wanted to contact the Human Dignity Trust for those kind of references and so on, you'd be happy to provide them to that. And what they would need to look you up on www.humandignity.org. Is it what is the
right. Humandignitytrust.org? Yeah, that's right.
Okay. And so please, anybody who's here who wants to pursue that, just look that up on the web, and then get directly in touch with Téa, who'd be able to give you some pointers in relation to your area and neighborhood. Yes, so I've been also asked to thank Edwin in particular for the cameo appearance of his cat. I have to say, for the first minute or two, I did wonder what it was obscuring the screen. But anyway, it really does come to the time to thank you both for really, you know, interesting, informative, incredibly concise and comprehensive, Téa, just giving us that overall picture. And as I said, the maps were just so illustrative, I think, of your point that we have made progress. And I often think that I don't know of any court that has moved from a decision like Bowers v. Hardwick to a decision like Lawrence v. Texas in such a short space of time. And that is not just a change in the law, that is a fundamental change in the underpinning of society. It doesn't mean it's complete or absolute or even resistance against regression, but it's a real mark of an extraordinary change. And I think that, you know, that was illustrated by your maps. And to thank both of you for the work that you and commitment with which you have engaged with these issues. And it's really been great to have you both here today. So on behalf of everybody who's here, thank you. And to thank everybody who has been here, thank you for being here. And just to remind you that we've got a couple of other events this week which you may be interested in attending. In fact, this is definitely South African Constitutional Court Alum Week, because on Friday evening at the Mansfield Public Talks, which are co-hosted this week with the Bonavera Institute, we have Edwin and my former colleague, Justice Dikgang Moseneke, talking about his latest book, All Rise, and also talking about his earlier book. Justice Moseneke has a very extraordinary life story. He was the youngest person ever imprisoned on Robben Island at the age of 16 for resistance against the apartheid state, and he went on to become the Deputy Chief Justice and a most distinguished Deputy Chief Justice. So for those of you who'd like to attend that, that will be on the Mansfield Public Talks. It is on the Bonavera website as well. On Monday, we continue with our Slavery Past and Present series, and this time looking at the question of immigration and empire. It has some strong correlations with some of Téa's presentations today, and we have a distinguished panel of speakers there, including Wendy Williams, the author of the Lessons Learned report in Out of the Windrush Scandal. So I do warmly recommend that as well. And then next Tuesday at the discussion group, we will be having a conversation with Renata Utz, Professor of Constitutional Law at the Central European University, halfway between Budapest and Vienna, sadly, talking about the normative underpinnings of the concept of academic freedom in human rights law. And she'll be responded to by Dr. Stefan Theil, one of our postdoctoral fellows who works in this field. So that's an array of events. We hope we'll see you at one or more of them. But meanwhile, thank you for attending, and a warm thanks to Téa and to Edwin. Bye.
Pleasure. Thank you. Bye.